In 30 years on the family court bench, I presided over more than 2,000 probate disputes. 200 of them began with the same act. A widow or a widower over the age of 70 walked into a county clerk's office, signed a marriage license, and within 4 years the estate they had spent half a century building was cut in half. The children of the first marriage walked out of probate court with less than they expected. In some cases, they walked out with nothing at all. My name is Thomas Warren. I served 30 years as a judge in the Family and Probate Division before I retired at 62. I did not retire because I was tired. I retired because I had watched the same preventable mistake destroy the same kind of family 200 times in a row. And I decided I could do more good speaking publicly than staying silent behind a bench. Every case I describe today has been anonymized. Names are changed. Details are composite. The pattern is real, and the pattern is what I want you to understand. The case I want you to follow began in the spring of 2012. The man I will call Harold was 71 years old. He had been married to his first wife, Margaret, for 47 years. They had raised 2 children together, a son named Daniel, then 44, a daughter named Sarah, then 41. Harold and Margaret had paid off their house in 1998. They had built a small commercial cleaning business that employed 11 people. Margaret was diagnosed with pancreatic cancer in March of 2011. She died 14 months later, in a hospice room with Harold holding her hand. Daniel and Sarah took turns sleeping in the chair beside her bed for the last 3 weeks. Harold stayed in that house alone for the first time in his adult life. He was 69 years old, and he had not slept in a bed without Margaret in it since he was 22. Sarah told me much later that her father did not cry at the funeral. He cried in the parking lot of the supermarket 6 weeks afterward when he reached for a brand of coffee Margaret had always preferred and realized she would never drink it again. Harold sat in my courtroom 7 years after that morning in the supermarket, on the wrong side of an inventory hearing, learning what his second marriage had cost the children of his first. Harold was not a careless man. He had read every contract he had ever signed in his life. He had built his business by being the first one to ask the awkward question and the last one to put his name on a piece of paper. But grief does something to a careful man that is difficult to describe to anyone who has not seen it from the bench. Grief narrows the field of vision. It turns the future into a single corridor. You stop calculating because calculation begins to feel like betrayal. 14 months after Margaret's funeral, Harold joined a grief support group at his church. He met a woman there. I will call her Linda. Linda was 58 years old. She was a widow herself. Her own husband had died of a heart attack 2 years earlier. She was kind. She was attentive. She listened to Harold talk about Margaret without flinching. And that, more than any other quality, was what reached him. They began dating 6 months after they met. They were engaged within a year. They were married 22 months after Margaret's death. The wedding was small. It took place at the country club where Harold had played golf for 30 years. Daniel and Sarah attended. They were not asked to be in the wedding party. Sarah told me that she stood in the back of the room during the ceremony and tried to feel happy for her father. She told me she succeeded for about 40 minutes. Daniel did not speak to his father for 6 weeks after the wedding, and then he called and apologized, because he had decided that his discomfort was his own problem and not his father's. The 2 children of the first marriage made a private decision in those weeks. They decided not to interfere. They decided to trust their father's judgment. They decided that whatever financial conversation needed to happen was a conversation their father would have with his attorney, because their father had always been the one who handled the documents. They were 44 and 41 years old. They were grown professionals with their own families. They believed, as most adult children believe, that their father had it under control. I want you to listen carefully to what I am about to describe, because the chain of legal events that destroyed Harold's children's inheritance was not the result of one dramatic decision. It was the result of 3 small omissions, each one of which looked reasonable at the time. The first omission. Harold and Linda did not sign a prenuptial agreement. When his daughter Sarah asked him about it on the phone, 2 weeks before the wedding, Harold told her that bringing up a prenup with Linda would feel like an insult. He told Sarah that Linda had her own modest savings, that Linda was not after his money, that the very act of asking for a prenup would suggest he did not trust her. Sarah did not push. She loved her father. She did not want to be the one who introduced suspicion into a marriage that had brought him back to life. The second omission. Harold did not update his will after the marriage. The will he had signed in 2003 left everything to Margaret first, and then to his two children equally if Margaret predeceased him. After Margaret's death, that will had effectively become a two-way split between Daniel and Sarah. After Harold married Linda, that will was, under the laws of his state, partially revoked by operation of marriage. Partially, not fully. The portion left to Margaret was extinguished. The portion left to the children remained on paper. But on paper is not the same as in force. Because in his state, as in most states in this country, a surviving spouse has what is called an elective share. The elective share is the thing most families have never heard of, and it is the thing that ends the inheritance most parents assume their children will receive. Under the law of Harold's state, a surviving spouse, no matter what the will says, no matter what was promised to the children, has the right to claim a fixed percentage of the estate. In Harold's state, that percentage was 33% at the minimum, and it climbed with the length of the marriage. By the time Harold died, the elective share Linda was entitled to claim was just under 40% of the probate estate, and that was before any jointly titled property was even discussed. The third omission. During the 4 years and 3 months that Harold and Linda were married, Harold added Linda's name to 3 accounts. The checking account, the brokerage account that held most of his retirement savings, and, most consequentially, the deed to the house. The deed was retitled as joint tenancy with right of survivorship. Harold did this in the 2nd year of the marriage, on the advice of a financial planner who told him, correctly, that joint tenancy would avoid probate on the house. What the planner did not emphasize, and what Harold did not ask, was that joint tenancy with right of survivorship transfers the entire property to the surviving joint tenant the instant the other joint tenant dies. The house did not pass through Harold's will. The house did not pass to his children. The house passed to Linda the moment Harold's heart stopped. The will he had signed 20 years earlier, the will that named Daniel and Sarah, had no legal force over that house at all. Harold died in November of 2016. He was 76 years old. He went to bed on a Tuesday and did not wake up on Wednesday. The cause of death was a hemorrhagic stroke. He had been at his daughter Sarah's house for dinner the previous Sunday. He had told her, on the front porch as she walked him to the car, that he was finally beginning to feel like himself again. Daniel and Sarah expected what most adult children expect. They had read their father's will once, 4 years before he died, and they remembered the language. They believed they would each inherit half of their father's estate, with Linda receiving whatever the marriage had brought her in jointly held savings. They did not know about the elective share. They did not know what joint tenancy meant. They did not know that the will their father had signed in 2003 had been overridden in 3 separate ways by the structure of the second marriage. The first surprise came 2 weeks after the funeral. Sarah drove to her father's house on a Saturday afternoon to pick up a box of family photographs that her mother had kept in the upstairs hallway. The locks had been changed. Linda answered the door, polite, composed, and explained that she was the sole owner of the house now, and that visits would need to be arranged in advance. Sarah called Daniel from the driveway. Daniel called the family attorney. The family attorney called me 3 weeks later, after the inventory was filed, and asked if I would consider hearing the matter. I did. If you have a parent who is widowed, or if you yourself were widowed in the last 5 years, this part of what I am saying is the most important. I am not telling you not to remarry. I am not telling you to suspect your new partner. I am telling you that the law in this country was not designed to protect the inheritance you assume your children will receive. The law was designed to protect the surviving spouse, and the law does that work whether you intended it to or not. If this conversation is one your family needs to have, please share this video with whoever needs to hear it, and subscribe so I can continue doing this work. The comments under this video are read. I read what I can. Now back to Harold's case, and to the moment that turned a family probate dispute into a public lesson. The hearing took place 14 months after Harold's death. Linda was represented by a probate attorney from a regional firm. Daniel and Sarah were represented by the same family attorney their father had used for 30 years. The inventory of Harold's probate estate listed 3 categories of assets. There were retirement accounts that totaled $940,000. There was a brokerage account that totaled $390,000. There was the cleaning business, which had been valued by an independent appraiser at $1,160,000, although the actual sale price would later come in lower. The house, valued at $610,000, was not listed on the probate inventory at all because it had passed outside of probate by joint tenancy. I asked counsel for the surviving spouse to clarify her client's position. The attorney did so, calmly and without theatrics. The position was simple. Linda would not contest the will because she did not need to. Linda would simply file her elective share claim. Under the statute of the state, she was entitled to 37% of the augmented estate. The augmented estate, by definition, included not only what was in probate, but also a calculated portion of jointly titled property and certain transfers Harold had made during his life. After the calculation was performed by the court referee, Linda's elective share entitled her to approximately $1,200,000 of the augmented estate. Sarah was the first to understand what that meant. She turned to her brother in the gallery and said one sentence I have never forgotten. "Daddy thought he was leaving us the business." I do not know if Linda heard her. The court reporter recorded it. It is in the transcript. Linda took the stand later that morning. Her testimony was short, and it was, I should say plainly, lawful. She testified that Harold had been a good husband. She testified that they had discussed the structure of their finances together. She testified that Harold had been the one to suggest adding her name to the deed and the brokerage account and the checking account. She testified that Harold had told her, on more than one occasion, that he wanted her to be financially secure if anything happened to him. She did not testify, and she was not asked whether Harold had ever told her that the structure of those accounts would override his will. I do not believe Harold understood what the structure would do. I do not believe Linda was obligated, as a matter of law, to explain it to him. The math, when it was finally done, came out as follows. Linda received the house, which had passed by joint tenancy. Linda received half of the brokerage account, which had been retitled as jointly held. Linda received her elective share against the rest of the estate, which she chose to take as a combination of cash from the retirement accounts and a 40% equity stake in the cleaning business. Daniel and Sarah, between them, received the remaining 60% equity in the business, the remaining portion of the retirement accounts after Linda's elective share was paid, and a small amount of personal property. The total value of what passed to the 2 children of the first marriage, by the court's accounting, was less than what either of them had assumed they would receive individually. The business did not survive intact. Daniel and Sarah did not have the cash to buy out Linda's 40% stake. Linda did not want to remain a silent partner. Within 18 months of the hearing, the business was sold to a regional competitor. The 11 employees were retained, then reduced to 7 over the next year. The name of the company, the name Harold had built for 41 years, no longer exists. The proceeds of the sale were distributed according to ownership. Linda received her share. Daniel and Sarah received theirs. The amount each child of the first marriage received, when everything was finally tallied, was less than 30% of what their father had built. Daniel told me, in the hallway after the final order was entered, that the worst part was not the money. The worst part was the photographs. The locks on his childhood home had been changed twice in the 18 months between his father's death and the sale of the house. The boxes of family photographs that Margaret had organized, year by year, decade by decade, were never recovered. Linda told the court she had given them to a charity because she did not know who they belonged to. The photographs were not on any inventory. They had no monetary value. They were not subject to any order. Daniel and Sarah had not thought to ask for them in the first weeks because they had not believed that there would be a reason to ask. They had assumed the house would come to them. They had assumed there would be time. Linda did nothing illegal. Linda did nothing that could be described in the legal sense as wrongful. Linda exercised rights that the law of her state had granted her by default the moment she signed the marriage license. Harold did not draft the laws of his state. Harold did not know, when he added Linda's name to the deed, that he was transferring the house outside of his will. Harold did not know that an elective share existed. The notary who handled the deed did not tell him. The financial planner who suggested joint tenancy did not tell him. The attorney who drafted his will in 2003 was not consulted at the time of the second marriage. By the time anyone with the legal training to explain it was in a position to speak, Harold was buried. I want to be precise about what I am asking you to take away from this case. If you are over the age of 60 and you are considering remarriage, there are 3 documents that determine whether your children of the first marriage inherit what you intend for them. And these 3 documents matter more than the conversation at the rehearsal dinner, more than the letter you write your kids the night before the wedding, more than the verbal promise you make to anyone. Let me name them clearly. The first document is the prenuptial agreement. The prenup, properly drafted in advance of the wedding, with independent counsel for both parties, can waive the elective share and define what each spouse brings into the marriage as separate property. A prenup signed without independent counsel for the new spouse is vulnerable to challenge. A prenup signed under time pressure, in the week before the wedding, is vulnerable to challenge. A prenup that strikes a court as grossly unfair to the new spouse is vulnerable to challenge. The prenup must be drafted carefully. It must be signed early. The new spouse must have her own attorney review it. If you are unwilling to ask for a prenup because the conversation feels like an insult, you are choosing the comfort of the engagement over the financial future of your children. That is a choice. The law will treat it as one. The second document is the updated will. A will signed before the second marriage does not protect your children because in most states the marriage triggers an automatic partial revocation. The will you signed before your wedding is a will the law will not fully enforce against your new spouse. You must execute a new will after the marriage, drafted by an estate attorney who knows the elective share law of your state, and you must understand, when you sign it, that the will does not override the elective share. The will is the second line of defense, not the first. The third document, and this is the one almost no family addresses correctly, is the title structure of your major assets. The deed to your house, the retitling of brokerage and retirement accounts, the beneficiary designations on life insurance and pensions. These documents, taken together, control the disposition of more wealth than your will controls. If your house is held in joint tenancy with your new spouse, the will does not reach the house. If your retirement account names your new spouse as primary beneficiary, the will does not reach the retirement account. The beneficiary form supersedes the will. The deed supersedes the will. The will controls only what is left after every titled and beneficiary asset has been distributed by its own document. You must inventory every titled asset you own. You must look at every beneficiary form. You must understand, in advance of the wedding, and again after the wedding, what each document is going to do when you die. I am going to add one more rule, because the cases I presided over taught me that families almost never address it until it is too late. If your estate includes a closely held family business, a farm, a rental property, or any asset that cannot be easily liquidated, you must address that asset specifically in your estate plan. The elective share is paid out of the estate. If most of the value of your estate is locked in an illiquid asset like a business, the new spouse's claim against that estate may force a sale. Your children may end up as minority owners in their own family business, with a step-parent who has no operational interest. They may be forced to sell. The business your spouse and you built together over 40 years may not survive your second marriage. There are legal structures that protect this kind of asset: trusts, buy-sell agreements, life insurance purchased to fund the elective share without forcing a liquidation. These structures must be in place before the second marriage, not negotiated after the death. I will tell you the last thing I told Daniel and Sarah on the day of the final hearing in the hallway outside the courtroom. I told them that nothing they had done had caused this outcome. I told them that the law had functioned as the law was written to function. I told them that their father had loved them, and that the absence of 3 documents was not the absence of his love. It was the absence of preparation. The absence of preparation is what most families bring to the second marriage, because the second marriage feels like a private decision and not a financial one. By the time you understand that the second marriage is also a financial decision, the documents that would have protected your children are documents you no longer have time to sign. If anyone you know is widowed and is considering remarriage, send them this video. It is not advice against remarriage. It is the conversation the family rarely has, given by the person who saw what happens when the conversation is not had. I will continue doing this work. I am grateful that you stayed until the end. This is Judge Thomas Warren.